Good afternoon, everyone. I, C.S. Mohan Kumar, Council Member of ICSI. I extend a very warm welcome to the eminent speaker and all participants in the 10th session of EEE series, Master Knowledge series, which focuses on legal framework governing appointment of KMPs. The concept of key managerial personnel, or we shortly call it as KMPs, it was introduced under the Companies Act 2013 and represents a very big shift towards greater accountability and structured leadership in corporate India. The roles of the managing director, full-time director, CFO, CEO, and company secretary are not only crucial from a compliance standpoint, but also they form the backbone of a responsible corporate governance. For company secretaries in particular, being designated as a KMP marks a significant elevation in professional responsibility and strategic involvement in board-level decision-making. In recent years, we have witnessed significant developments in the legal and regulatory framework concerning KMPs, from stricter appointment criteria and disclosures under SEBI LODIA regulations to procedural shifts brought by MCA V3 and digital compliance mandates. These changes underscore the importance of staying informed, aligned, and proactive. Keeping in view the ever-changing legal environment and the interplay between SEBI, LODR requirements and the Companies Act, particularly with regard to the appointment, removal and remuneration of KMPs in listed entities, it calls for a detailed deliberation, particularly in respect of practical application of the statutory provisions related to KMPs among company secretaries, who play a crucial role in ensuring corporate governance and regulatory compliance. It is in this context, today's webinar seeks to offer deeper insights into the statutory provisions, practical challenges, compliance requirements, and governance implications surrounding the appointment and management of KMPs. Now, to delve deeper into the legal framework of appointment of key managerial personnel, we have with us C.S. Ramaswamy Kalidas, Practicing Company Secretary. It is an honor to be given the opportunity to introduce him before all our learned members. Mr. Kalidas, he is a fellow member of Institute of Company Secretaries of India and he is an MBA in Finance from Jadavpur University, Kolkata. With more than 4 decades of experience in industry after starting professional career in the year 1978, currently he is practicing as a practicing company secretary. He worked in leading companies such as Ambuja Cements and ACC Limited. He also served as the company secretary and senior VP of Reliance Power Limited for 7 years. He authored more than 100 articles on issues relating to corporate law, SEBI regulations, corporate governance, etc. Currently, he is associated with the ICSI as member of Secretarial Standard Board, SSB, and we are extremely happy to have him here. It is a proud privilege to have him as a speaker for today's session. Let me once again extend a warm welcome to all the participants and the speaker present today. We trust today's discussion will enrich our understanding and contribute to our collective pursuit of excellence in governance and compliance. All participants are requested to raise their queries through the chat box, and same will be taken up at the end of the presentation by the speaker. Kalidas sir, over to you, sir.
Thank you very much, Mr. Mohan Kumar, for a warm introduction. Good afternoon, everyone. It's always a pleasure to participate using the podium of platform of our alma mater. And after all, learning is a never-ending experience, and however much one may be ingrained in terms of length of experience in the profession, there's always a scope for learning. And today we are going to delve into a very, very important aspect of the law, namely, as Mr. Mohan Kumar mentioned, the Companies Act 2013 actually represents a paradigm shift in terms of quality, in terms of an endeavor to enhance the levels of corporate governance as compared to the predecessor act of 1956, which actually had, by the turn of the century, outlived its existence and usefulness, and there was a lot of deadwood to be cut out, and the law had to be fine-tuned to meet the dynamics of the economic environment in this country, especially after the doors of liberalization were kept open way back in 1991. and the economic environment therefore demanded that we have a law which is contemporaneous and in tune with the environment, and also in tune with the expectations of the stakeholders that have come from far and wide, as opposed to the protective environment that we had prior to the liberalization process. Now, with this background, let me deep dive into the subject. But before I do that, there are two, typically I always make a disclaimer at the beginning of my presentation, in the sense that whatever I'm going to be saying in terms of opinion or views, etc., are entirely my own, and there it has got nothing to do with the institute nor the firm with which I am associated with. And of course, some of the views you may not agree with, some you may, but then it's a democratic society we live in, and everyone has a right to disagree. And what I shall do is that, given the fact that the amplitude of the subject is not very vast, I've I've attempted to look at the micro provisions surrounding the requirement of appointing KMPs, and therefore and I have also tried to find answers to some questions which I often come across from the members of the fraternity as to what should be done in a particular situation. Now, with this background, let me start my presentation. Can we have the presentation rolled out, please? The first slide. Yeah, as I said, this is the presentation is all about the legal framework associated with the appointment of KMPs and case studies. I mean, there is not much in terms of case study where it comes to the judiciary, because this is a section which has not been tested very substantially, given the fact that the law is only a decade old. But even then, from my experiences in industry and in handling practical situations, I shall, give you some insights into certain specific problems which I have dealt with, and perhaps attempted to find a solution there too. Let's go. Next slide, please. Yes, as Ms. Mohan Kumar mentioned, this is the concept of a KMP is a development in the Companies Act of 2013 under a specific provision called Section 2, subsection 51. And although the act was actually made effective from 1st of April of 2014, this particular section defining the KMP was actually made effective much earlier, from September 12, 2013. And the basic trigger for the introduction, as I said, of this law was firstly the fact that the Companies Act of 56 had become somewhat antiquated and out of tune with the times, and it was appropriate that there should be a relook at certain critical areas. And there was a central government appointed committee which went into the nuances of the law, submitted a report on the company law suggestions for changes way back in the year 2005. And the report did acknowledge the role that was played by very significant personnels in the company, such as the managing director. Of course, the managing director, the manager, and the company secretary were concepts, and the whole time director were concepts which we associated with the 56 Act as well. But then there was nothing much by way of material available in terms of explaining the responsibilities. In fact, the duties of the company secretary were never explained in the under the regime of the 56 Act under Section 383A. So it was considered appropriate and befitting to identify the criticality associated with such positions and explain the responsibilities and the expectations of the stakeholders from those that hold these mantles. Now, one of the recommendations of the committee was that the appointment of such people should be in a full-time capacity, and should be in only a single company. Now, having said this, when we dissect the provisions of Section 203, we will find that there is a clear dichotomy between what was expected by this company law committee and the law, in the sense that, in a limited sense, the law does allow certain persons to be associated with more than one company, and from that perspective, it is a contradiction and a letdown in terms of the expectations of the committee vis-a-vis the actuality of the law. The committee also suggested that there should be you see, compliance does come with a cost, and there are certain companies where the compliance requirements are minuscule, and these companies may not be in a position to afford the luxury of appointing high profile people to positions such as managing director or company secretary or CFO, and therefore the committee felt that it should be appropriate to identify the financial thresholds, so that this requirement was only subjected to companies of a particular genre and companies of a particular size, and therefore financial thresholds have been prescribed insofar as the appointment to these positions are concerned, purely with the intent to eliminate from the rigors of associated with the appointment where it comes to small and marginal companies. Next slide, please. Yeah, Section 251 starts with the means definition. It says key managerial personnel means. Now, we are aware that a means definition under the law is actually a rigid and inflexible definition, in the sense that it is incapable of, its amplitude cannot be extended beyond the words that have been used in the statute. So we'll have to restrict ourselves to only as opposed to an inclusive definition, which is an extensive definition, where it is possible for you to extend the dynamics of the definition beyond the words which indicate that the legislative intent is to make the definition all comprehensive and extensive. That is not intended where it comes to a means definition, and therefore we will have to restrict the concept to only the terminology that is used within Section 251. And Section 251 says KMP in relation to a company. So therefore, you need to appoint a KMP only in the context of a company. Now, why I'm saying this is that there are certain provisions in the Act which apply also to an LLP, which under the LLP Act is considered as a body corporate. So it's important to understand that the requirement of a KMP is only to a company. Now, who are these KMPs? KMP refers to the Chief Executive Officer. The Chief Executive Officer has been defined under Section 2, subsection 18 to mean an officer of the company. An officer has been defined under section 259, and chief executive officer therefore refers to one who's an officer of the company who has been designated as the chief executive officer by the company. Now, by the company does not necessarily mean by the shareholders. The company being an amorphous body, it has to be represented by certain individuals which provide the brains and arms for the company, which is the board. So we are referring to somebody who's been appointed to the position of a chief executive officer, who is an officer of the company and who's been appointed to that position by the board, right? Now, we will later on during our discussion, I shall explain the dichotomy in the law and in what manner the law is a big letdown where it comes to recognizing the role that the chief executive officer is supposed to play. Then it also refers to the managing director. Now, who is a managing director? Managing director is defined under section 2, subsection 54 to mean, firstly, a director. A managing director is a director who, by virtue of the articles or by an agreement with the company, or in terms of a resolution which has been passed by the shareholders in a general meeting or by its board of directors is entrusted with substantial powers of management of the affairs of the company, and it also includes a director occupying the position of the managing director by whatever name called. So, firstly, what we need to understand is that before you appoint a managing director, unless that person already is a part of the board as a director, you need to appoint him as a director. The board has to appoint him firstly as a director and thereafter designate him as a managing director. Now, the managing director derives his powers. The law does not define what represents substantial powers of management. It defines substantial powers of management in a negative manner to identify what are not to be considered as exercise of substantial powers, such as routine powers like the power to sign checks, the power to sign issue a power of attorney, the power to sign promissory notes on behalf of the power to approve transfer forms and things like that. These are not supposed to be part of the substantial powers of management which the managing director is supposed to exercise. And it is also the definition is somewhat of a mix in the sense that it is a means. It starts with the means, the expression means, and then it also extends the amplitude of the term managing director to include a director occupying the position of the managing director by whatever name called. Now, this is a situation which you normally associate where a company does not have a managing director and it has only a whole time director, right? In that situation, the law has established that where the company does not have a managing director and only a whole time director, the whole time director's position is analogous to that of the managing director, right? And that is exactly why you are having an inclusiveness associated with the definition to cover a person who is occupying this position of the managing director, regardless of whether he is being designated as such. Then it also includes the word manager. Manager. Who is the manager? Now, manager is also a position which is somewhat analogous to the managing director, except for the fact that it is commonly understood that the manager is not supposed to be part of the board. Section 2, subsection 53 defines a manager as somebody who's an individual. See, look at the inconsistency in the use of expressions. A managing director has been referred to as a director. I mean, it doesn't say the managing director is an individual who's a director. Although it is an admitted fact that the Supreme Court also has recognized the fact that a director is only an individual. But there are ironically some provisions in the Act where the expression person is used. Now, person has a wider connotation than an individual, but the General Clauses Act says that which gives the definition of person explains that the connotation associated with the expression person needs to be restricted or constricted according to the context in which it is used. Now, here we are talking about a manager who's an individual. So obviously, you cannot have somebody who is a firm who is appointed as a managing director. I assume that the use of the expression individual in manager is actually a fallout from the old act in 19 under the 1956 act. You had the position of managers and secretaries, the which was a system. The managing agency system was abolished in the year 1969, and perhaps this is the aftermath of the removal of that concept in the law, that they have used the expression manager individual to define a manager. He's an individual who is subject to the superintendent's control and directors of the company. So obviously, his whatever he does, he is according to the direction and supervision of the board, and he has the responsibility, very similar to that of the managing director. He has the responsibility of controlling substantially the whole or the whole or substantially the whole of the affairs of the company, and it also includes a director or any other person occupying the position of the manager by whatever name called, whether it is under a contract of service or not. So, therefore, a manager is supposed to be, although the law assumes that the manager is not a part of the board, but the section says that you could call somebody a manager who is also on the board. So you could have somebody who's doubling up as a director and a manager as well. And it also, you need not call this person specifically as manager, although it would be ideal to call him so because of the use of the terminology in the law. And secondly, this person need not be under a contract of service, or you can be he can be a full-time employee without being restricted to a contract of service which is extendable for a certain period. However, under section 197, where you are appointing a manager as also a whole-time director or even a managing director, remember that the tenure of the managing director or the whole-time director or the manager cannot extend beyond 5 years at a time, right? Now, the company secretary is again a pre-existing position in the from the Companies Act of 1956. The old timers are aware of the introduction of Section 383A in the Companies Act in way back in the year 1975, which provided for the appointment of a full-time company secretary in certain companies. And I remember when the law was introduced, the threshold for appointment was only 25 lakhs. It was 25 lakhs, and then subsequently it was increased to 50 lakhs, and I think it became 5 crores. And today, under the new act, you have the requirement only 10 companies that have a share capital of 10 crores. Now, who's a company secretary? A company secretary is somebody who's defined as under clause C of subsection of the subsection 2, section 2 of the Company Secretaries Act of 1981. I think the requirement is that you should be a member of the associate member of the Institute of Company Secretaries of India, because prior to the introduction of the Company Secretaries Act, actually quite a few people who had not qualified in the examination of the institute were admitted as members by virtue of the fact that they were probably holding a diploma in. There was a concept of a GDCS. You had a government diploma in company secretaryship, which should enable you to be appointed as a company secretary as well. Now, the company secretary, for the first time in the law, the definition, the company secretary's functions have been identified under section 205, and we will see the some of the functions that have been laid down and the expectations that are assumed to emanate from the role that is to be played by the company secretary. And then next comes the whole-time director. Now, why does the whole-time director come in order of preference in the third category? Is because you have, normally if you have a managing director, you do not have a whole-time director unless it's a very, very large company which demands that there has to be specific areas which should be identified for exercise of authority by a whole-time director. Now, who is a whole-time director? Section 294 defines a whole-time director. See, this is the this is the contradiction I mentioned. Section 294 defines a whole-time director as a person who's one second. Yeah, it includes. This is defined inclusively to refer to a director in the whole-time employment of the company. Now, I'll explain what is whole time. Can you go to the next slide, please? Next slide. Yes, the whole time, the concept of whole time director I'll come to little later, because there is a case law in the Bombay High Court which I'll explain. Then the final authority that has to be appointed as a anointed with the position of a KMP is the Chief Financial Officer. Now, where it comes to the whole time director, it refers to somebody who's in the whole time employment of the company. So there is a clear distinction that you can find from a managing director's definition, the whole time director, definition, because managing director, the law doesn't say that he is supposed to be in the whole time. He's well, admittedly, he's expected to be involved full time in the company, but the law does allow him to be associated as a managing director in another company, subject to the unanimous approval of the second company. Now, the final position is that of a CFO, and the CFO has been defined to refer to a person. Now, unlike in the case of unlike in the case of the manager who is referred to as an individual, the CFO refers to a person, and the term person, as you know, as per the General Clauses Act, includes also a juridic person such as a company. But as I explained to you, the extension should not be given to the expression person unless the situation so demands, and that is why you have the extension given to the definition of a person in the Income Tax Act, like under Section 2, subsection 13. The term person is extended to cover individuals, association of persons, HUFs, partnership firms, what have you. So here you cannot extend the concept of person to mean artificial entities. You have to refer to CFO as only an individual who has been appointed as a chief executive, rather a chief financial officer of the company. Now, there is a further scope for extension of the concept of a KMP. Now, this is again rising out of the demands that modern businesses are, making out of the board. We have today, we do not recognize a company only in terms of its financial standing. We recognize a company for its quality, not only in terms of its profitability and the return that it is providing to its shareholders, but also in terms of its contribution to society, in terms of its contribution towards protecting the environment and all that. And therefore, we have now a triple bottom line approach where it comes to recognizing the quality of a company. And given the fact that other functions such as environment, marketing, manufacturing, etc., are also extremely important in the context of companies, the law gives the latitude to the board to identify certain other persons who are one level in terms of hierarchy. They are supposed to be in a position which is one level below the directors, but however they have to be continued, they have to be associated with the company in a full-time capacity, and they shall be designated as KMPs. Now we have the concept of the senior management under the LODR regulations, also by which persons who are, let's say, in charge of marketing, or for that matter in charge of environment or sustainability, are also recognized as senior part of senior management and identified as KMPs by the boards. Of course, the law does not give such extension, so there is therefore a flexibility which is provided under the law to extend the concept of a KMP to include any other functionary which the board considers to be appropriate. And the final clause is the residual clause, which is this is intended to every definition normally as the residual clause, so that you can widen the concept of the definition. So any other person not covered hitherto before can also be prescribed as a KMP, and there is no prescription so far in the Act, either by way of any insert in the rules or in the Act. So this is the residual clause has not been invoked yet by the powers that be. Now, the KMPs, as I said, are considered as officers under Section 259, and this section specifically identifies the KMPs in accordance with whose directions or instructions the board or any one or more of the directors are accustomed to act. Now, by this extension to the concept of an officer, people that are in charge of functions such as secretarial, such as finance, such as marketing or manufacturing may also be may also be considered as officers depending upon the decision of the board, and these people will be responsible for the functions for which they are specifically given responsibility, and the board is dependent on their directions. Like the company secretary is, for instance, supposed to be the conscience keeper of the board, and he's supposed to guide the board where it comes to matters of law. So similar would be the case of somebody who's handling the environment for the board, for the company, or for that matter, marketing, because he would be the one who would be aware of the nuances associated with the law that relates to certain products such as power, cement, etc. Now, the KMPs are, why is it necessary to identify these people as officers? Because Section 260 comes with the penal clause, in the sense that if there is any non compliance in the specific areas of responsibilities that have been identified to these functions, these persons will be considered as officers in default, and therefore they shall be liable for specific prosecution or proceedings by the concerned authorities for violation of the areas that are. So this actually, in a sense, insulates the board from responsibility. The board can therefore identify certain persons and say that these are the ones that are responsible. Not that it takes away the collective responsibility of the board for certain specific situations, which of course is not a matter of our study for the day. Now, let us be very clear at the beginning that the position of the KMP is not ornamental. It is not a sinecure. A sinecure, as you know, is a position which does not demand much of responsibility, like the president of India. I mean, who's only a titular head and a constitutional head without much of executive authority. So this KMP position is not ornamental, or let us be clear that it's a position which comes with a lot of thorns. No, it's like you are wearing the hat of a KMP, with and the hat comes with a lot of thorns, because you are beset with considerable amount of responsibility, and therefore this position calls for application of tremendous amount of maturity, clarity of thought, and sound temperament. You see, you are likely to be tested in situations where there is a crisis, and it is your clarity of thought, your maturity, your sound temperament that will take the board out of the quagmire that it is set in. And therefore, this is a mantle which comes with the cost, with comes with certain responsibility, and demands adroit handling where it comes to the person holding the position. So you can't have somebody who's immature, and who he would be completely disastrous where it comes to upholding the responsibilities that are laid on the company's KMP. Next slide, please. Yeah, what are the thresholds for appointment? Section 203 has to be read conjointly with Rule 8 of the Company's Appointment and Remuneration of KMPs. And Rule 8 sets out the categories of companies to which the appointment applies. Now, Rule 8 applies to every listed company and every other public company with a paid up share capital of rupees 10 crores. Originally, it was 5 crores or above. So, firstly, it apply. I'll explain that the as you are aware, the term listed company has been diluted considerably by the amendment to Section 252. Previously, even a private company which had listed its non-convertible debentures in the stock exchange could be considered as a listed company. But now the definition has been restricted and narrowed down to only cover equity listed companies and high value debt listed companies, which are issuing debentures where the outstanding as of now is rupees 1000 crores or more. Now, and as I said, and it says every other public company. So it could also include a unlisted public company which has a paid up share capital of 10 crores. Now, an unlisted company would also, to my public company, will also include a subsidiary of a of a public company, whether listed or not. If you are a subsidiary of a public company, by the operation of law, you are considered as a under Section 272. You are considered as a public company, and therefore it also applies to a subsidiary of a public company. Now, what is the as I said, the Rule 8A was introduced in by the Amendment Rules 2020 to raise the threshold for appointment of a whole-time company secretary in private companies which have a paid-up capital of 10 crores and above. Now, the point to ponder here, this is my first salvo for the day, whether a company secretary appointed in a private company with the above threshold capital should be considered as a KMP, whether he is a KMP. Now, in my view, he is not to be considered as a KMP for the following reasons. Firstly, Section 203 contemplates appointment for prescribed class of companies, right? Please notice the word prescribed class of companies. And where is the prescription? Rule 5 provides a prescription to the class of companies which need a KMP. Rule 5 says that the prescription for appointment is for listed and other public limited companies with the threshold capital as above. So clearly, a private company is out of bounds where it comes to Rule 5. And shall I say, with due apologies, Rule 8A actually was a introduction which was a knee-jerk reaction of the government. In fact, I recall the time when Mr. Arun Jaitley was the finance minister. Once the law was introduced, there was a hue and cry from especially the youngsters in the profession that there was the section did not call for the appointment of a company secretary in private companies with the paid up capital of even the paid up capital of 5 crores. There was a hue and cry, and then it was considered appropriate that such companies should also have company secretaries. Now the company secretary in a private company is not a KMP for also another reason, because Rule 8A only calls for the appointment of a company secretary where it comes to a private company. It does not call for the appointment of a CFO. It does not call for the appointment of a managing director. It does not call for appointment of a whole-time director or a manager unless such positions are appointed voluntarily. So, in my view, anybody who is appointed as a company secretary of a private company with a paid-up capital of 10 crores is not a KMP through the operation of law unless he is acknowledged as a KMP by the board and he's treated so and he is entrusted with the responsibility. So that's an entirely voluntary requirement. Next, to make him a KMP. Now, I have explained that the listed company, previously, any company whose securities were listed in the stock exchange was a listed company, and there has now been a restriction insofar as the application of the expression listed company effective from 22/1/2021. The amplitude of the definition of the listed company has been restricted to cover only equity listed and companies which have issued non-convertible debentures on private placement basis which are listed. Now, of course, the threshold is 1,000 crores for a HBDLE, high value debt listed equity entity, and non-convertible redeemable preference shares issued as per the extant SEBI regulations or both. 203(1) calls for the appointment of whole-time KMPs, right? Who's a whole-time KMP? Now, it calls for the appointment of whole-time KMPs, and the first list is MD or CEO or manager, and in their absence, a WTD. Now, notice the expression or after MD or after CEO. The term or, when used in legislation, is actually considered as a disjointing conjunction in that it separates words. It is not as opposed to the expression and. And is an aggregative conjunction which cumulates. See, or is normally used to refer to a clause which is mutually exclusive. So you could have, in the context of a company, a whole-time managing director or a CEO or a manager. You don't have to have a managing director. Of course, a managing director and manager cannot coexist under the law. You can have a managing director who's also called a CEO, right? And if you do not have a managing director or a CEO or a manager, that's when you appoint a whole time director, right? Now, I will come to this CEO a little later, but for the present, we can rest assured on this premise that the company needs to appoint only a managing director or a CEO or a manager, and in their absence, a whole-time director. So it's not necessary. Of course, there are quite a lot of companies which have got whole-time directors in addition to the managing director, depending upon their size. So there is no such thing which is sacrosanct to say that if you have a managing director, you cannot have a whole-time director. Having said that, if you have a managing director, you cannot have a manager, right? Then it calls for the appointment of a whole-time company secretary. It calls for the appointment of a whole-time chief financial officer. Next. Now, what is the meaning of the expression? I've used the expression whole time ad nauseum, and I have not tried to explain what is whole time. You see, in law, we need to understand the meaning of every word, because there is one principle in law where it says that no word in the law should be considered as excessive, right? And every word should be considered to have a certain meaning, unless it is completely repugnant to the context, unless it is completely dysfunctional to the objective of the law. What does the word whole time mean? Whole time refers to full time, as defined in Ranganathan Iyer's legal lexicon. Black's dictionary defines the wholly as entirely, completely, whole and soul, that is, fully, totally, and in every respect. So, therefore, the incumbent who is appointed as a KMP is supposed to be wholly committed to the company, given the ethos that are associated with the concept of a KMP. Now, why do you appoint a KMP? Because a KMP is being appointed only with the intention to uphold the concept of corporate governance, to ensure that the board runs along as a fine-tuned machinery and answers to the expectations of the stakeholders where it comes to governance, quality, and what have you. And the Bombay High Court has given a very interesting definition to what is whole time, who is a whole time director. In Ramaben Tanewala, the Bombay High Court has defined a whole time director to refer to someone who spends his whole time in the management of the company, in the same sense as a managing director does. So he's supposed to be devoted whole time in the management of the company. That is exactly why a whole time director cannot be the whole time director in another company. Having said that, there is a dichotomy I find in the law in subsection 3, which allows a managing director of one company to be a managing director of another. Now, in fact, even where it comes to subsection 3, the expression whole time has been compromised substantially, because all these functionaries, the managing director, the CEO, the whole time director, the manager, the CFO, can be associated as a KMP of not more than one company, which is its subsidiary. Now, so therefore, if you are a company secretary of a holding company, then subsection 3 allows you to be the company secretary of your subsidiary, right? If you are a managing director of one company, of a holding company, you can be the KMP of the subsidiary. Does it not contradict the expectation in the section 203, which talks about whole time involvement? And again, the next question that arises, quite a few people have asked me, because when, as you are aware, under Section 13 of the General Clauses Act, the term single masculine covers the feminine gender and vice versa. Anything used in the singular sense is supposed to also consider the plural sense, unless such a construction is repugnant to the context of the law. So, therefore, the question that arises out of subsection 3 is that, can I not only be whole-time company secretary of one subsidiary, why not more than one subsidiary? To my mind, here is where the law needs to be interpreted very strictly, and it should not be widened to enlarge the expression company to include more than one company. Managing one company in a whole time capacity as a company secretary itself is a very huge responsibility. Now, being made responsible for a company secretary of the subsidiary company is double whammy. And I am aware of many companies which are abusing this provision in the law, including certain listed companies. In my view, it runs contrary to the expectation of the committee which was appointed in 2005, where the expectation was that there should be an association with a single company. And to my mind, this leeway that is allowed by subsection 3 should be plugged in the interest of the law, in the interest of ensuring that there I know of one person who was the company secretary of two listed companies. The one listed company was the holding company, the other listed company was its subsidiary. And not only did the holding company have the same person as the company secretary of both the companies, but the same person was the managing director for both the companies. The only saving grace was that both the companies were in the same line of business. But does it, justify tweaking the law to your advantage to this extent? In my view, therefore, there is a serious need to relook at the law and to plug the loophole in the law by which subsection 3 should not allow the association of a full-time, whole-time KMP with even its subsidiary, right? This is my personal view, and I'm not saying that it should be acceptable, but I mean, as somebody who's interested more than academically in the concept of corporate governance, I am making a very strong pitch for an amendment in the subsection to ensure that this subsection is not sort of abused, subjected to abuse, right? Next slide, please. Yeah, the proviso, there is, look at this, whilst subsection 3 allows you to be associated with the subsidiary company as a KMP, now the proviso, unlike the listing regulations, the proviso under subsection 1 contemplates restrictions on a single person holding the position of the chairman and MD and CEO also. In the sense, if you will recall, under regulation 17(1)(b) of LODR, there was a provision that a company cannot be a listed company cannot have a executive chairman. Therefore, you cannot have a person who is donning the position of chairman and managing director. But this was initially, I recall, this was kept on hold up to 2022, and finally it has been withdrawn. But subsection 1, on the other hand, discourages an individual from being the chairperson as also the CEO or managing director of the company pursuant to the articles simultaneously, unless the articles provide otherwise, or the company does not have multiple businesses. The facility to have CEOs for different businesses verticals has been given by the second proviso under the subsection 1. So subsection 1 clearly discourages an individual from being associated with the same company as the chairperson as also as the CEO or managing director. Now, whereas the LODR is a stricter provision where it comes to listed companies. LODR provides a latitude to continue with the executive managing director. I'm aware of the compulsions which do not allow this restriction to be removed. Perhaps because, see, after all, India is a country where capital is not the prerogative, is only the prerogative of a few. So you and I can't start a business. Even if we dream, unless we have support, financial support, governmental support, and things like that. So therefore, given the fact that the capital is the prerogative of only a few, I guess that this restriction with regard to the holding of the position of the executive chairman has been withdrawn in the SEBI regulations purely due to the due to the economic environment in this country where most of the companies are owner driven. Now, the second proviso, as I said, to subsection 1, exempts the applicability of the first proviso to those companies which are engaged in multiple businesses and which have appointed CEOs for each such business. And there is a notification dated 25/7/2014 which provides the exemption to public companies with a paid up capital of 100 crores or more, which are engaged in multiple businesses and they have appointed CEOs for each line. So this is a exemption which is available for companies of a certain category with a capital of paid up capital of 100 crores and which have business verticals, separate verticals for each activity. Next. Now, can then the next question that I am addressing to you is, can a KMP be appointed through a circular resolution? Because there is a chink to my mind in section 203 subsection 2. Subsection 2 of section 203 says appointment of the KMP can be made only by a resolution of the board setting out the terms and conditions. It talks about only a resolution of the board. A resolution of the board, as you know, can be passed either at a board meeting or through a circular resolution. So the question therefore arises whether the resolution for the appointment of a KMP can be considered through circular resolution. Now the answer to that is no. One, because you see, if you look at the objective of the section, why are you appointing a KMP? To ensure that certain functions which demand the kind of attention which they require are provided the kind of attention by persons who are responsible, who have the necessary qualifications and ability to steer the company through the choppy waters of the ecosystem. Right. So, in tandem with the principles of harmonious construction, which is consistent with the objective associated with the section, we can say that the appointment of a KMP cannot be by circulation. Now, also, you get strength, this thought also gets fortified by section 179(3), which defines the powers of the board and provides for the appointment of a KMP only by a resolution which is considered at a meeting of the board. And further, the Secretarial Standard 1, paragraph 1.3.8, the annexure which gives the negative list of items which cannot be transacted through circular resolutions provides that you cannot appoint a KMP through a circular resolution. Now, where it comes to the appointment of a KMP, if you have a NRC, which is a requirement for those companies which satisfy the thresholds of finance capital of 10 capital turnover of 250 crores or borrowing of 100 crores, where you have an NRC under section 178, the appointment of the KMP has to be preceded by a recommendation which is made by the NRC, and based on the recommendation of the NRC will not only recommend the appointment but also the terms and conditions, including the remuneration to be paid to the KMP, and Based, if there is an NRC in the committee, in the company, then based on the NRC's recommendation, the board will take a decision in the matter. Right now, ironically, under the LODR provisions, where it comes to the appointment of the CFO, appointment of the CFO also, this is in the terms of reference of the functions of the audit committee. The appointment of the CFO has also to be approved by the audit committee. Now, I therefore feel, whereas 178 contemplates the recommendation of the NRC where it comes to the appointment of the CFO, not only do you need the approval of the board, but also the approval of the audit committee. So I reckon the process for appointing a CFO should be firstly recommendation by the NRC, followed by the approval of the appointment by the audit committee, and finally the nod of the board. Right. Next. Now we come across I'm particularly, I'm aware of many companies which are conglomerates. Many companies where you have, let's say in a company like Reliance, you've got hundreds and hundreds of companies. Large groups of companies have many subsidiaries and for separate activities. And now there is an arrangement which such companies have, in terms of which there is a seconding arrangement in terms of appointment of KMPs. I'll explain that a little more specifically. Say, let us assume that there is one company which has got a threshold capital of 20 crores, right? And therefore, this needs a company secretary. Now, there is another company which has only a threshold capital of 5 crores, does not need a KMP, does not need a company secretary. Now, can it be arranged as between the two companies that this person who is employed on the roles of the company which has a capital of 5 crores, can his services be lent to the other company which has a specific need under the law to appoint a company secretary, and there is an agreement between the two companies whereby the cost of employment is either borne by the company with which he is associated, with the rider that his services are entirely lent to the other company. You could have lending of the services to the other company with the cost of the service, with the cost of the employment being also transferred to the second company, with the employment remaining in with the person incumbent remaining on the rolls of the company. Right now, such kind of an arrangement is quite often to be seen in the context of conglomerates which have a huge number of subsidiaries. Now, whether this is an appropriate arrangement has not yet been tested under the present law, to the best of my knowledge. But there is a decision in state of Gujarat versus Coromandel Investments Private Limited, which is reported in 71 case, where the court ruled that inasmuch as the expectation of the law was that the company secretary shall be engaged in a full-time capacity with the company, despite being the employee of another group company, there was compliance of under the law under section 383A. So what did this company do? The group company which did not require the company secretary lent the services of the company secretary to the other company which had a legal need. And the question which was raised by the registrar was whether the state was whether this person can be considered to be a full-time associated person with the company which needs the company secretary, because he is not on the rolls of the company, he is on the rolls of the another company. But there was the court held that there was compliance of law, because what was the need? The need was that there should be a full-time company secretary, and that need had been satisfied by virtue of the first company seconding the services of this person to the second company. And there was unanimity in consent, where the court came to the conclusion that this was substantial. There is a principle in law also which is called as the principle of substantial compliance, where you don't have to go into the nitty gritty of the finer points of law, as long as the objective associated with the legislation is met. Now, I am not aware whether this law will get tested, because under the the mechanism now which we have under the law, this trigger happy authority under the MCA are constantly fining companies for small aberrations. So I fancy that this may not meet with the requirement of law. But then there is a, if somebody has to explain the rationale, I think there is considerable force in the argument that there has been substantial compliance of law in terms of the arrangement between the two companies, and the requirement that a KMP should be there in the company which needs to have a KMP has been met, right? And as I said, the theory of substantial compliance with the statute would also corroborate the above view. Next. Now, can the same person hold two KMP positions in the same company? Now, we talked about the KMP in one company being KMP in another under subsection 3, which is allowed as long as the second company is a subsidiary. Now, we have found in the case of many companies, including listed companies, that the same person is holding the position of two KMPs. Like, for instance, I cannot mention the names of companies for obvious reasons. I'm aware of large listed companies which have a company secretary who's also doubling up as a whole-time director. There is a whole-time director who's also doubling up as a CFO. I have not come across somebody who's the managing director, company secretary, and CFO. That would be actually stretching the law too far. But I fancy that in these days where multitasking is the need of the hour, to my mind, there is nothing wrong, in as much as I am paying complete respect to the concept of full-time involvement. Supposing you have a company, you see, company secretaries, it is not often that you find that a company secretary who is a pure company secretary is fully tied up in secretarial matters, particularly if it is a company which is not a very widely actively traded company, or where substantial control is with the promoters. Because remember, your floor public holding needs to be only 25%. So you could have a promoter who is controlling 74.9%, and the stocks are not widely held. So therefore, a company secretary who's appointed in that kind of a scenario would probably, I reckon, be twiddling his thumb for most part of the day, unless he is beset with huge number of problems. He's also given the responsibility of legal functions and all that. So in such a situation, in my view, law should not, you see, what is the purpose of law? Law is supposed to be a facilitator for rational action. Is there anything irrational in appointing in making the same person don two hats within the same company, as long as that person is able to deliver, right? So to my mind, there is I think there is one reported case in Bini Limited, where the registrar of companies has adjudicated and slapped a penalty for a company secretary, for a CFO who was also holding the position of whole-time director. But notwithstanding all that, to my mind, in as much as it does not vitiate the principle that the person who is holding two positions is whole time committed to the company, albeit in two capacities, to my mind, there is nothing wrong in the same person holding two positions in the same company. And I'm drawing some my justification for this is also drawn from a very old decision in 10 Com case, HM Ibrahim Seth versus Metupalayam Narayani Bank Limited, where the Madras High Court held. The Madras High Court is quite famous indeed for giving some, uncommon judgments. So therefore, I'm not saying that this is the last word on the law. The Madras High Court held that a director could also hold the position of the secretary and conduct court proceedings, including insolvency proceedings, right? So this settles the issue to my mind where it comes to whether the same person can hold two positions in the same company. Next. Now, there is 203 has there is also a salutary provision in 2033 which says that there is a proviso. Now, firstly, let us understand what is the purpose of a proviso in a statute. The purpose of a proviso is normally is a clause which carves out an exception. It carves out a stipulation containing a qualification to the preceding clause. Says provided that means whatever is mentioned in the earlier clause will be subject to satisfying the requirement contained in the proviso. Now, what does the proviso under subsection 2033 do? It allows the KMP of the company to be a director of any other company with the permission of the board. Mind you, it talks about only being a director. It does not talk about being an executive director. So, if I am the company secretary of a holding company and my subsidiary needs a director, I can be appointed a director in a um, in a non-whole time capacity, in a non-executive capacity, and however, for that I need to take the permission of the board. See, it is very, very often found that in large companies with huge number of companies in their basket, you don't go out of your way to find directors from outside, particularly if it is a subsidiary company. So senior persons in the employment of the company are appointed as directors of subsidiary companies. However, they cannot be, as I said, be associated with an in an executive capacity uh, unless of course this you draw courage from what subsection 3 also says that you can be KMP of the other subsidiary company, right? Now here we are not talking about being KMP of the other company. We are talking about being director of the other company with the permission of the board. Now the appointment, however, as I said, cannot be in an executive capacity. Now, the person who is also the KMP in the company can also be appointed as an independent director in an unrelated company. In an unrelated company, subject to the board of the company in which he is employed agreeing to that appointment and the incumbent satisfying the test of independence in the other company. So if I am the company secretary of one company, and if some other company which is completely unrelated to the group wants me as a independent director, I am aware in my previous employment, my CFO was independent director on the board of a large listed company, and we gave permission. The board did give permission because there's nothing wrong, because it's not an executive position which comes out with a huge amount of responsibility. Next. Next slide, please. Yeah. Appointment of the same person as the managing director or manager of two companies. The third proviso under section 2033 says that any person who is acting as the managing director or manager of one company can be appointed as the managing director or manager of another company subject to the following. One, the second appointment being approved by a resolution at a meeting approved by the entire board, of which specific advance notice has been given in the agenda provided to the board. So, this is possible that you are a managing director of one. This is the point I made, which is a dichotomy to section 2031, which talks about whole time involvement. So, why on earth should the law allow a managing director to be managing director or manager of another company when the expectation that he or she should be associated in a whole time capacity? I cannot see the logic of it because, to my mind, it runs contrary to the intention of 2031. And of course, I am aware that this is a complete, repeat of what the previous law allowed. Under the old act, also, you could be appointed as a managing director of another company with the approval of the unanimous approval of the board of the appointing company. But those times, the environment, the economic environment was very difficult. Very, so beg your pardon, not difficult, very easy. In fact, I recall in my formative years as company secretary of a listed company, I had very little to do. You could pass off with a board's report under section 217 of the old act. The board report could you could have a board report which is only 3 pages in length. Now, today, look at the board report. I mean, it runs into pages and pages. And mercifully, with the stoppage of issue of physical copies of the annual report, a lot of kabadawalas have lost business because most of the annual reports would invariably go to the kabadawala, right? In fact, I recall a shareholder in ACC who held, he's no more, may his soul rest in peace. He had 8 shares in 8 folios, 8 shares in 8 folios. And before every AGM, I retired in 2019 when the physical copies were a requirement. He would come to me and say, please give me 8 copies of the annual report. Although SEBI, I'm aware of a circular of SEBI which says that if there are shareholders in a family, one copy will suffice. But how would I explain this to this man? I told him jokingly that he was taking away more than the dividend by way of copies of the annual report. So therefore, it was 450 rupees to a copy, and ended up paying 450 multiplied 8 times to satisfy the requirement of his. Now, so therefore, in my view, this is those days it was very easy to be a listed company secretary or a managing director of a listed company. And in fact, one of the provocations for listing in the old days, those of you who are familiar with the income tax law will know that a listed company was considered under the income tax law under section 2 subsection 18 as a widely held company. One of the explanations for a widely held company was that it had to be listed. And why was it considered necessary to be a widely held company? Because the rate of tax at that point in time was lower for a listed company, which is why many companies made a beeline for listing because the requirements for listing were minuscule. It could be met in a day, but today it's not possible to sort of fiddle with the law so easily. So in my view, I'm very strong in my opinion. As I said, I don't want you to support my view, but these are my views, and I stick to my principles steadfast regardless of the criticism I meet with. But I am completely opposed to the concept of allowing the managing director of one company to be managing director of another because it is also counterproductive to the concept of corporate governance. And as I said, this provision is being misused by many companies, including listed companies, and it is dysfunctional to the legislative intent. The legislative intent is to usher in corporate governance in every aspect, and this provision is dysfunctional to that. How can somebody give the same attention to two companies? I cannot understand. Next, can the then comes the next question: can a person be the whole-time director in two companies simultaneously? Now, look at the definition in section 2, subsection 94. It says whole time director includes director in whole time employment of the company. So, clearly, a whole time director is an employee of a company. He is an employee of the company. On the other hand, if you contrast it with the definition of managing director in section 254, the managing director, of course, there are certain purposes for law of law where he has been acknowledged for, I think ESI is acknowledged as a full-time employee. But the Income Tax Act does not treat uh, particularly a promoter managing director who's not interested in being associated as a managing director for the salary he draws. In cases involving the remuneration of the managing director who's engaged in a promotional capacity, in the capacity of a promoter in the company, the income tax law has held that that income shall not be taxed as income under the head salary. It shall be considered as income from business. So you cannot therefore put the whole-time director and the managing director in the same pedestal where it comes to treatment as an whole-time employee. Now, the other reason why there is a difference between the MD and the whole-time director is that the MD has been endowed under law with substantial powers of management. Substantial powers of management, need not be defined. I mean, it can be defined by saying that that which is not routine is not exercise of substantial powers, signing of checks, etc. But per law, as I said, under the income tax law, the managing director in many cases has been held not to be an employee, and his remuneration has been held to be professional income, especially where he is a promoter of the firm. However, the whole-time director, as I said in the Bombay High Court decision, which I quoted in my earlier slide, has recognized him to be an employee. And the annual report, interestingly, I came across this when I did my research for my book. I came across this report of the Department of Company Affairs for the year 1957, and that recognizes the whole-time director as one rendering services in a whole-time capacity to the management of the company. So having said this, to my mind, you cannot be the whole-time director of two companies. Okay, you can be the managing director with a caveat, as I said, of two companies, but you cannot be the whole time director of two companies. And the exception carved out under subsection 2033 is only in the case of a managing director. Next. Next, please. Yeah, time limit within which the replacement of a KMP has to be made. What is the time frame within which the KMP has to be replaced? Right? 2034 says that whenever there is any vacancy in the office of a whole-time KMP, it has to be filled up within 6 months from the date of occurrence of such vacancy. Now, this is actually contrary to Regulation 6 in LODR, or for that matter, if there is even Regulation 17(1)(e) of LODR says that if there is a vacancy in the office of a director which needs to be filled up, the vacancy should be filled up within 3 months from the date of occurrence, right? The extended time frame of 6 months is available only to the in the case of unlisted companies, right? One second, please. As per Regulation 6, as I said, the company secretary is considered as a compliance officer, and that also clearly says that the vacancy should be filled up within 3 months from the date of such vacancy. And LODR also provides another requirement, which has been, I found, violated by one of the listed companies in their filings. I won't name again the company. LODR also says that the vacancy in the office of a company secretary or a CFO shall not be filled up provisionally. You cannot appoint somebody as a pro tem company secretary or a pro tem CFO. Now, this requirement has been violated by one listed company. I will not mention the name, but coming to the point I'm making, where it comes to filling up the vacancy in the office of a KMP, the law allows a period of 6 months to fill up the gap. Whereas under the LODR provisions, the time available is only 3 months. Okay, even where it comes to the appointment of an additional director, whereas the law allows the additional director to be regularized at the next AGM, LODR says that you should appoint him, you should regularize within 3 months. That is exactly why many of the companies who appoint additional directors are coming out with postal ballots. Next. Now comes to I've worded this slide accordingly. The curious case of the CEO who's not part of the board under the law. Now, if you look at 251 again or 203, there is nothing which says that the CEO should be part of the board, right? It says 251 says a KMP shall be managing director or CEO or manager or whole time director, right? So the law does not contemplate. It is ironic when you call somebody chief executive officer. Now, this guy is supposed to be the pivot. This guy is supposed to be the head of the organization. I mean, that is what the terminology connotes. But ironically, you do not say that when you appoint somebody as a CEO, you don't compel that company, if it is not a listed company, that is, to appoint that person to the board, right? Now, so therefore, you could have somebody who is considered as a CEO, but he's not a board member. In fact, in my personal life, again, I will not mention the name of the company. I was the company secretary and manager of the company, and we had the CEO who was not a board member. So I had although my CEO was an extremely professional man, I gave him all the respect. But one day I told him, Sir, as per the provisions of law, you come under me because I am the manager of the company, whereas you are not even part of the board. Now, this is something which actually, in fact, ironic that rule 3 of the appointment rules provides for the filing of MR1 only in the case of the appointment of managing director, WTD, or manager. It does not require that you file a CEO, you file a MR1 when you appoint a CEO who's not part of the board. Now, SEBI regulations, however, assume that the CEO is part of the board because invariably, whomsoever is the managing director whomsoever is the CEO is generally the managing director of the company. So, and because of the fact that the CEO theoretically need not be a part of the board, even his remuneration is not subject to limits under Section 197. This is a complete, misnomer where it comes to the application of a terminology which is not, coming with the trappings of authority which the law should necessarily provide for. Again, this is a dichotomy in the law which calls for a review. In fact, I wrote an article which was published in the CA Club India.com, The Curious Case of the CEO Under the Law. And it came up for big, there were a lot of hits to that article inexplicably. But I find this very strange that the law still allows somebody to be CEO of an unlisted company, and of course, and even if he's not part of the board, right? And I think there is a review called for in the law where you call somebody as a CEO and yet do not make him part of the board. That is, it's like a child who's given the candy but not allowed to eat the candy, right? Like Henry Ford said about money. Henry Ford made a beautiful remark about money. Money is like the limb of our body. Either you use it or lose it. So if you don't use it, you lose it. So here you have somebody who's called a CEO who it is assumed, at least even by the principle of holding out or estoppel, By the principle of holding out, he is considered to be a functionary who is part of the board, the highest echelons of management. Yet the law allows him to be not part of the board. And I firmly feel that there is a requirement to plug this dichotomy in the law. Next. Now, I will, before I, there is one portion which I did not cover. Mr. Mohan Kumar pointed out that I shall also be talking about removal of KMPs. Actually, I have not included removal of KMPs, but since he mentioned that I would be talking about it, I would, before we discuss this particular portion, I'll talk about the removal of a KMP. Now, what is the need for removal of a, how do you remove a KMP? Now, suppose you remove a company secretary or a CFO. Does he have a right of representation before the board? Does he have a right to present his case to the shareholders? Of course not, because he is not a part of the board. So if you remove a company secretary or a CFO, you will have to give no explanation to the shareholders. You could, in that case, the right, the more diplomatic manner in which there is a removal is through asking him to resign, so that there is no black mark also in his career record. So, however, if you remove a director, if you remove a managing director, or for that matter, even you remove a director who is not even in an executive capacity, Section 169 comes into play, right? 169 says that if you want to remove a director, regardless of whether he is in an executive capacity or in a non-executive capacity, that can be done only through the issue of a special notice by a member. What is a special notice? Special notice is by somebody who has 10% of voting power. If he or she feels that the managing director or so and so director is incompetent, he can issue a notice to the company and seek the removal of the director. And under the law, under the Companies Act, to the best of my recollection, the removal resolution to be approved by the shareholders is only an ordinary resolution, but under the SEBI LODR provisions, the requirement is a special resolution. Now, as soon as the company gets a notice for the removal of a director, what, and suppose the notice is given by a person who has got the required authority in terms of voting power, what is the requirement that is to be done? The requirement that is to be done by the company is that the notice will have to be, say, suppose the notice has been received before the issue of the notice for the annual general meeting, very well it can be included in the notice for the annual general meeting. But the law allows the notice to be given 14 days prior to the date of the general meeting. 14 days. So, if the notice for the annual general meeting has already gone, how do you include this? You can't include this. So, therefore, you attempt to include this by sending an advertisement or sending mails, or of course, today it is possible because now you are sending notices through email, but previously it was not. And I'm assuming that the law will remain the same after September. But how do you communicate with your shareholder that you have received a special notice for the removal of a director? And the removal of a director is not an easy process. Once the notice is received, the company will inform the board, the company will inform the shareholder, the company will also inform the director concerned. The director concerned, like the auditor, will also have to be served a copy of the notice for his removal. And the law recognizes there is a fine, distinction in the terminology used in the law as far as the rights of the director who is sought to be removed. The present law says that the director who is sought to be removed shall have a reasonable opportunity of being heard. Reasonable opportunity to be heard has been explained by the Supreme Court in a landmark decision. The earlier law talked about the remover, the director sought to be removed shall have the right to be heard. He shall have the right to be heard. Now the law says he shall have a reasonable opportunity of being heard. That means that he shall be allowed the right of representation. Now, how does he express his right of representation? Either he can write a letter and say, I am not violative of any provision, I cannot be removed, I have done this, and this is my track record, I cannot be removed. I can either send a letter to the management, which has to be circulated to the shareholders, or I can make a representation at the floor of the meeting. Interestingly enough, there is a chink in the law where it comes to the exercise of the right of representation by the director sought to be removed, by the auditor sought to be removed, and today by the secretarial auditor sought to be removed. The chink is, suppose I receive the notice for the removal 14 days before the annual general meeting. The notice for the meeting has already gone to the shareholders. The e-voting process has already been set in motion. Many of the shareholders have already exercised their vote. Now, how is the shareholder going to, how is the director concerned or the auditor concerned be given the right of representation? How will he express his right of representation? There is no answer to this in the law. If I want to make an presentation to the shareholders on the floor of the meeting, yes, today I can do so. I can attend virtually. But the point is, everyone, the e-voting process is already over. Everyone has voted. So, what is the point of my voice would be a voice in wilderness? That is exactly why, you see, some reports are made with a lot of attention and care, but they are not considered seriously. The quota committee recommendations for LODR provided that the e-voting process for listed companies should be allowed to continue until the midnight of the AGM. Why? Because in that case, those shareholders who are attending the meeting will have the flavor of the meeting. They will know what is happening. So they will be in a position to vote also on this resolution. But unfortunately, the law is one sided where it comes to exercise of the power of the managing director or the director or the auditor or the company secretary or secretarial auditor sought to be removed. The right of representation cannot be exercised under the present position in the law for listed companies. So this is again a submission I had made to SEBI also, had made to the Ministry of Corporate Affairs, but uh, the common man is not heard, right? Next we come. So I thought I would cover this portion because this is not part of my presentation. Okay. Then next we come to the managerial remuneration. Managerial remuneration is again a terminology which is used to signify certain managerial personnel. Section 196 and other provisions are applicable only in the case of the managing director, the whole time director, and the manager. So these persons' remunerations are regulated by Section 197, read with Schedule 5 of the Act. What is the ceiling? The overall remuneration ceiling is, as you are all aware, 11% of the net profits computed under Section 198. In the case of inadequacy or absence of profits, you will be guided by the effective capital of the company computed in the manner as laid down under Schedule 5. Now, talking of schedule, now there is Schedule 5. There are three parts to the schedule. First part is what are the conditions to be satisfied by the incumbent. And might I say, part A of Schedule 5 applies to even private companies. Sections 197 and 198, 197 do not apply to a private company where it comes to ceiling on remuneration, but Part A of Schedule 5 does apply to the appointment of a managing director in the case of a private company, in the sense that he has to ensure that he satisfies the conditionalities laid down in Part A. Now, why do we need schedules? Why do we have so many schedules in the Act? What is the purpose of having a schedule in a legislation? You have, for instance, schedule 3, which lays down the format of the balance sheet. Schedule 5, you have got so many other schedules where it comes to several other provisions. Act. The reason why you have schedules is basically to avoid clutter. If you have too much detailing in the law, it becomes very difficult to read. Say, suppose 197 were worded in such a manner that it covered payment of remuneration to, in case of companies which are having profits and not having profits also, then it is very difficult to get a stranglehold on the section. But if you put so much detail, it is going to make it impossible to understand the law. So the need to have schedules is basically, it emanates from the need to avoid clutter and excess detailing in the mother legislation. And schedules are part of the law, and as long as they are consistent with the law, they are considered to be part of the law very much. If, however, the schedule states something which is not consistent with the Act, in that case the Act will prevail. Where it comes to the remuneration of the managing director and the whole time director, the law provides for a ceiling of 5% on net profits. And if there is more than one such director, MD and whole time director, the ceiling is 10% of the net profits. And in case you want to pay remuneration in excess, then you will have to pass a special resolution under 197. And the law today also allows, uh, in fact, I say this is a very salutary change in the law, because today the law allows even the non-executive directors to be paid. If you are not a whole-time director, how do you get remuneration? You get remuneration only by way of sitting fees, and secondly by way of commission based on net profits. What happens if your company is not making profits? Then, apart from the remuneration that you get as sitting fees, you are not going to get any remuneration at all. So, therefore, there was a situation where even today, a lot of people consider the position of an independent director as not a very enviable position. Many people do not want to become independent directors. And supposing you tell me that you are going to get only sitting fees of 5,000 per meeting, and we will have 4 meetings in a year, then for 20,000 rupees, why should I take responsibility? So that is why the law has now said, after the amendment made in the year 2021, 18th of March 2021, there is now provision for payment of remuneration to even non-executive directors in case of absence or inadequacy of net profits. Now, in such a case, the remuneration is based on the effective capital of the company. However, if you are having a profit, you can pay the remuneration by way of commission based on net profits. If you have a managing director, there is a ceiling of 1% on the net profits, and if you don't have a managing director or a whole-time director, then you can go up to 3%. One second. Oh, yeah. Next. Uh, I'm almost coming to the end of my presentation, but I cannot but leave this presentation without mentioning what has happened what has happened to the profession very recently in the form of amendment to Regulation 6, and I consider this as a huge feather in our cap, in the cap of the profession of company secretaries, where, as per Regulation 6.1 of the LODR provisions, the compliance officer, of course, has to be a qualified company secretary, and a proviso has been added in terms of an amendment which has been made on December 12th, to the effect that the compliance officer shall be an officer in the full time employment of the company, standing at a level in corporate hierarchy which is not one level below the board. This is a fantastic development. That means that if you are a company secretary in a whole time capacity in a listed company, in terms of hierarchy, your position shall be one level below the board. That means you will be reporting to the board. And indeed, you have to be designated as a KMP. Now, this is a huge feather in the cap, and I compliment whomsoever was responsible for the change in this law entirely. But but with additional authority comes huge amount of responsibility. I am aware of a lot of companies where the company secretary does not, you poor chap, he is just qualified and the company needs a company secretary. The company secretary is not even been told about a meeting of the board. He simply signs the notice and he invariably reports to the CFO. He reports to the CFO. I mean, I'm sorry, it should be in my presentation. I've said his reporting cannot be any longer be with the CFO, not CEO, CFO. Now, in many companies, the company secretary inexplicably reports to the CFO. I find this very intriguing. The CFO does not know the ABC of company law unless he is double qualified. Most of the people who are CFOs are chartered accountants or MBA with specialization in finance. And why on earth should they be responsible for the secretarial function? Company secretarial function. So, therefore, today the law has been amended where it comes to listed companies that, in terms of hierarchy, the company secretary shall report to the board. Now, even if you are reporting to the executive director, that is good enough because the executive director is reporting to the board, right? So, if it is not that you have to report only to the chairman or to the MD, if you are reporting to the executive director, regulation 6.1 is satisfied. And there is a lot of confusion on this point, which SEBI has clarified in terms of their circular dated April 1, 2025. There's some confusion as to what constituted level. What is level? SEBI have clarified that in relation to the company secretary or the compliance officer, it refers to the position of the compliance officer in the organizational hierarchy. And SEBI has also issued two informal guidance notes on April 3rd, 2025, in the case of DCB Bank and Patta Limited, which corroborates the above view. There they have quoted, they have beauty that these two guidance informal guidances are worth reading because there is an extract that they have quoted from the report of the expert committee on LODR, and they have said that the company secretary comes with a huge amount of responsibility. He's in many companies. Of course, only one thing is that you have to, you see, as they say, it's only when you have it's only a old axe that can cut fine. If you are new to the profession, you may be confused with the provisions of the Act. So, therefore, the respect, etc., comes generally through experience and your ability to present yourself to the board. So if you are good in both, definitely the recognition which has been provided by SEBI would be 100% justified. And to my mind, this amendment in regulation 6 has cast upon the company secretary a very, very huge responsibility, and it is incumbent on us as members of the profession to ensure that we discharge our responsibilities in such a manner that we uphold the ethos associated with corporate governance. And the lot is expected from the company secretary, and the company secretary has it in him to deliver, and it is appropriate that his position has been recognized. I am aware that amendment to Regulation 6 has caused a lot of heartburn in other professions. But that is exactly the point I'm making. With increased responsibility comes increased expectation, and we need to discharge our responsibilities in such a manner that we come out on top in terms of ability to discharge our functions. Uh, I think I've done with my presentation. I kept 15 days. Okay, the last slide is there. There's a consequence of non-compliance with LODR and Section 203 where it comes to appointment of a KMP. If you fail to appoint a KMP, there is a provision for a penalty under subsection 5, and you are aware that um, registrars of companies are very trigger happy where it comes to imposing penalty for non-compliance with. In fact, the institutes has come out with a book on informal. It is a compilation of adjudication orders, and 90% of it I found is on Section 203 across the country. Of course, the offence is compoundable, which is why it is going for adjudication. Now, hefty penalties are being imposed, and therefore it is important and imperative that every company appoints a company secretary, or for that matter, satisfies the requirements of 203 where it comes to appointing a KMP. And the olden days, you could get away with an excuse. You send an advertisement in a newspaper which is not read and say that situations vacant, company secretary required. Then nobody sees that advertisement. Then you tell the registrar, I couldn't get a man. No, that is no longer acceptable. And there is a case law which has been, which is available, which says non-availability of proper resource is no defense for quashing proceedings under Section 203. Non-compliance by the listed companies also attracts penalties, not only where it comes to delay in appointment, but also in delay in filling up vacancies under the standard operating procedures laid down by SEBI. And the offense is viewed very, very seriously. With this, I come to the end of my presentation. I hope I have covered many vexed questions. If there are questions in the chat box, I'm happy to keep 15 minutes aside for questions.
Yes, sir. Thank you very much for.
Can you be a little loud?
Yes, sir. Thank you very much for a very, very detailed session, sir. There are queries, as a lot of queries, we will try to quickly answer them. I'm sure most of them you have answered in your presentation itself, but queries they have started sharing from the, I think, half the way through, but later you have covered few questions, but I'll go through it quickly, sir. If a private company where provisions of KMP is not applicable, but appointment of company secretary is a mandatory requirement. In this case, whether private company should mandatorily designate company secretary as a KMP.
I agree with you that, you see, one thing is that rules are subordinate legislation. Rules are subordinate legislation, and rules are supposed to be part of the act if they are consistent with the act. But if the rule says something which is beyond the act, it is inconsistent with the act. To my mind, Rule 8A is inconsistent with the act in the sense that it restricts the appointment of a company secretary to only a private company. But having said that, I already said that it is, if you appoint a company secretary in a private company with a capital of paid 10 crores, you can by all means consider him as a KMP, and the board can pass a resolution that he is a KMP, he is an officer under section 259, he will be considered as a officer in default under section 260.
That you have answered this question, but still they have asked, I mean, though not directly you covered it, can qualified company secretary holding company secretary position of the company and who is also a CA member can hold a CFO position at the same time?
Yes, there is no, to my mind, there is no bar. because as long as you do not compromise with the concept of whole time. See, I told you there are many companies. The most respected company, one of the most respected companies in India, has a company secretary and a whole time director. Now, has SEBI ever taken any action? Now, what you see, there is no need to appoint somebody, because there is a if as long as the position is being satisfied and the requirement of law is being met, what is the problem? In my view, this is, as I said, but there is a, I am aware, when I was in Chennai some years ago, one person came to me and said that registrar has slapped a penalty in the case of one company. That I said that, look, if you allow me to defend, I will ensure that the penalty is quashed. I don't know what became of that matter.
Okay, sir. A third person is asking whether a company secretary can act as a CEO.
Yes, he can be CEO, but then I think that will be too much, firstly, CEO is supposed to be a position where you are an all-rounder. I mean, you are supposed to be more of an entrepreneur at that position than a compliance officer. A company secretary is basically, his role is limited to compliance of law, Companies Act, LODR, everything, secretarial standards, what have you. So, although there is no problem in appointing the CS as the CEO, it's the same as whole time director and CS. It's the same as CS and CFO. But
Yes,
it's
sir.
very rare to come across that kind of an example. But I don't see that there is any challenge legally.
Another question is, he's asking, can an individual hold dual KMP position in holding and subsidiary? And he's also asking, in that case, is there any restriction to apportion the CTC between the two entities?
To apportion the what? See, no, that
CTC.
no, that is entirely left to the companies. As I said, seconding arrangement is completely left to the companies. If you are a company secretary of two companies, including the subsidiary company, you are satisfying the requirement of subsection 3. Now, many companies have an arrangement by which the shares cost is shared. If you don't want to do it, also you can pass a resolution that he will be the company secretary in company without remuneration.
Okay, sir. Another question is MR1. MR1, when should it be filed? After the board meeting or after the general meeting?
To my mind, the appointment is subject to the members. It has to be, appointment is on the date on which the board is appointing. So it has to be within 60. See, whenever the law says, unless the law says previous approval of the shareholders, it means that the board is empowered to appoint subject to the approval of the shareholders. That's why you take resolutions for appointment for remuneration to the managing director at the AGM or in an extraordinary meeting after his appointment. So MR1 has to be filed within 60 days from the date of the board meeting.
Okay, sir. In the context of unlisted public company, is it legally permissible for a company secretary to receive remuneration under a different designation, for example, deputy general manager, etc., rather than CS?
Why is it necessary? CS remuneration is not subject to any regulation. Is it subject to regulation even for a listed company? There is no regulation. So why he should receive remuneration as a deputy general manager and what have you? He receives remuneration. He can hold the position of CS and general manager. He receives remuneration as CS.
Can a KMP of a company become an independent director of any other company?
Yes, he can be subject to the approval of the company in which he is a company secretary, and that he should satisfy the requirement of independence in the other company.
Yes, sir. What is the penalty under SEBI LODR for non-appointment of CFO? For
That is,
CFO.
I think it is a per day penalty. I'm not offhand, I can't tell you the amount, but it is very heavy. I think it's 5,000 rupees or 10,000 rupees per day. if I recall correctly.
Thank you, sir. So our next question is they are asking CEO in certain companies he is appointed through articles or something, but he is not a member of the board. Whether those CEOs who are appointed, whether they will be regarded as KMP.
See, this is what I said. No, in the case, the law allows you to appoint a CEO who is not part of the board. But in the case of a listed company, because there is a different connotation, he is MD and CEO. But there is no problem in appointing a CEO who's not part of the board in the case of an unlisted company. And that is exactly the point I made. That is a regulation which needs to be plugged. The loophole needs to be plugged.
Okay, sir. Can a KMP be appointed on a contractual basis and not necessarily as a permanent employee of the company? A lot of
Absolutely,
government
no,
companies do this
no
exercise, sir.
problem,
They
no
take up
problem. He
government.
can be an employee for he can be a he can be under contract for 3 years. Yes, no problem. 5 years, whatever.
Can a company secretary be appointed in more than one subsidiary of the same holding company?
No,
Like,
I said this not. That is why please follow what I said in section 13 of the General Clauses Act. Clearly says that the interpretation that the singular includes the plural should be restricted unless in cases where there is going to be repugnancy. There is the law is going to be defeated. The objective of law is going to be defeated. See, in Singapore, I understand that if you can be a company secretary for 600 companies, right? There is no, so far as I am aware, that I knew about a lady who was a company secretary of 600 companies. Can you say the same about India? The complexity in the law is so much.
sir, another question is, can NRC remove a KMP based on the performance?
Of course, NRC will review the performance pay on, and it is the role of the NRC. How will the NRC assess the performance? They will take a report on the performance from the board, from the managing director, from the whole-time director, from the HR. There will be, there are now various practices for evaluation. There could be a 360-degree evaluation. Based on that, the remuneration will be decided, recommended.
Can a person serve as the managing director of 4 private limited companies within the same group, where 3 companies paid up capital is less than 10 crore and 1 private limited capital is more than 10 crore?
I think we are making a mockery of the law. I mean, I should not be. We should not be answering such questions or raising such questions, because how can you be managing director of 4 companies? Even if the capital is less than 10 crores, how can you wear so many hats? Theoretically, I will say yes, it is possible, because firstly, the managing director's appointment is not regulated under 197, but again, it is regulated. His appointment will have to be, he will have to see whether he satisfies 196, Schedule 5, Part A.
What is the timeline to appoint another company secretary when the existing CS resigns? Also, the timeline for a newly incorporated company when threshold is reached.
Timeline is within 6 months from the occurrence of the vacancy. So I reckon that in the case of a new company, if it is only just starting and then it has reached the threshold of 10 crores, I would say that you appoint a company secretary immediately without waiting for the threshold time.
Someone is asking if we designate a chief revenue officer as a KMP. I don't know how chief revenue officer can be a KMP, but okay, should we reappoint another CTO within 6 months of his resignation? No,
See, if
no.
the CFO resigns, then you see any position in the KMP has to be substituted by 6 months. I think this is only terminology. Probably this chief finance officer is called chief revenue officer, maybe in some government department or something. So the same logic, of course, for government companies, I'm not too sure what applies. But then, if a CFO resigns, the time is same as that of a CS.
Sir, I don't know. They're asking about independent director. Can an independent director be appointed for 3 consecutive years? That is 21 to 23, 23 to 26, 26 to 29, or can we appoint for 3 years and then reappoint for another term of 3 years?
This probably they are asking because of my article on independent directors in the Chartered Secretary of June. See, the independent director, where it comes to section 149, it talks about appointment of an independent director for a period up to 5 consecutive years. The term up to means that 5 years is the maximum. So within that, you can appoint somebody for 2 years. If you have appointed somebody for 2 years, in that case, that one term is over. Then, if you want to reappoint him, then your second term is happening. In fact, I have given this in the explanation in my article also in the Chartered Secretary in June issue. See, the second term cannot be for 7 years or 8 years because you appointed him for 2 years. So it can be for 2 years, it can be for 3 years, it can be for 5 years, two terms of 5 years each.
How CS can be protected against fines and actions initiated by regulatory authorities for fraudulent activities undertaken by board of directors?
You see, there is a very good decision of the SAT tribunal which has come as a big relief to the company secretaries, where it comes to certain statements which have been made in the issue document. The company secretary has been insulated by SAT tribunal. Similarly, I came across a decision where the company secretary, was penalized for violating the true and fair view of the accounts. Now, there the court has held that the company secretary is not responsible for accounts. You cannot, in fact, there is, I remember under the old act, there was a decision under section 215 to say that where a company secretary is signing the balance sheet, he is signing only in the capacity of a witness to the directors, so he does not have any responsibility. So if there is any, if he is held responsible for activities which are not part of his areas of responsibilities, then he can plead not guilty.
Last question. Do we need to file DR12 for reappointment of managing director when there is no change in designation?
I feel yes, it is. Appointment, the term appointment includes reappointment. So if a managing director is reappointed, then you need to file reappointment because you are taking the approval of the shareholders also for that. You are also taking the approval of the shareholders for the remuneration. So you have to file DA.
Thank you, sir. Thank you very much. We have taken almost all
Thank
the
you so much.
questions.
It was a pleasure talking to me. If it was a pleasure talking to. I do not know what was the what was the number of people who attended.
Around 18,000 to 19,000 members attended, sir. More than 18.
19,000. That is fantastic. Anyway, I'm very happy that I'm. You see, the disadvantage in a webinar is that you do not have eye to eye contact. So I do not know how many out of 19 stayed tuned till the end, but nonetheless, I enjoyed doing this presentation, and I'm very happy that the institute gave me this opportunity. And as I said, if there are there are certain views which I have given which do not meet with your expectations or your concept of law, then well, it's a democratic country. You have a right to disagree. Thank you very much.
Thank you, sir. Thank you very much. We sincerely thank you for a very, very detailed presentation which covered all the 3 KMPs and also patiently answering all the queries. It is very, very useful, and that's one of the reason why around 18,000 to 19,000 members have attended, and the numbers kept on increasing throughout the session. So we sincerely thank you, sir. We look forward to hearing you again in physical programs or in webinars, sir. Thank you. Thank you, Mr. Khan.
Most certainly. Thank you. Thank you so much.
Thank the Secretariat who have done a fabulous job. Thank you. Thank you very much. Sincere thanks to all the members who logged in. Thank you very much. The next webinar will happen on next Wednesday. Thank you. Thank you very much. Bye.
Thank you. Bye-bye.